This video, presented by the Truth in Action Share Club, addresses the question of whether grand jury theory falls under the category of organized pseudo-legal commercial arguments, or OPCA. We will explore the MEADS versus MEADS case. Is grand jury theory considered an OPCA? We'll examine the case of MEADS versus MEADS, a significant 2012 decision, and the distinction between pseudo-law and constitutional and common law arguments. The MEADS versus MEADS case is notable because Associate Chief Justice J.D. Rook created the OPCA category. This decision grouped recurring pseudo-legal schemes under one framework and became a reference guide for courts across Canada. The OPCA category was established to address recurring pseudo-legal tactics. Examples included Freeman on the land and sovereign citizen theories, as well as de-taxer schemes and related pseudo-legal movements. The court in MEADS versus MEADS held that several theories lacked legal foundation in Canadian law. This included flesh and blood versus legal person theories, secret birth certificate accounts, and self-created common law courts. The judgment explicitly rejected claims that individuals could exempt themselves from the law by mere declaration. Courts retain jurisdiction regardless of personal consent, and declarations of sovereignty do not remove legal obligations. The court rejected, quote, silence means agreement theories used to impose fees. Contracts require mutual consent, and sending documents to officials does not create binding obligations. The double or split person theory was rejected. This theory suggests a legal name in capital letters is a separate entity. The court found this legally meaningless. The judgment confirmed courts have specific powers against OPCA litigation. These powers include striking pleadings, dismissing actions, imposing costs, and declaring litigants vexatious. The court clearly distinguished between ordinary self-represented litigants and those advancing systematic pseudo-legal schemes. The ruling specifically targeted abusive or fabricated legal tactics, not general self-representation. The purpose of the decision was to create a reference guide. Justice Rook intended for courts across Canada to be able to recognize and respond consistently to OPCA tactics. It is important to note what the case did not do. It did not abolish common law arguments, constitutional reasoning, or jurisdictional challenges. The focus was strictly on fabricated pseudo-law theories. Could grand jury arguments be labeled OPCA? The ruling targeted pseudo-law, not historical or constitutional analysis. A grand jury argument typically relies on established legal elements, such as common law, constitutional structure, and legal history. Courts regularly hear arguments involving unwritten constitutional principles, common law powers, and historical jurisdiction. These are recognized forms of legal argumentation, unlike OPCA theories. OPCA theories often rely on concepts like secret accounts, strawman theories, and claims that courts lose jurisdiction without consent. These were found by the court to be disconnected from recognized legal reasoning. A constitutional grand jury argument does not rely on secret contracts, imaginary bank accounts, or commercial redemption theories. Instead, it traces authority through legal sources and constitutional reasoning. Labeling an argument OPCA does not automatically make it so. A proper challenge addresses the actual legal authorities cited. The distinction is between fabricated legal fictions and recognizable legal reasoning.